but I want to thank you for participating in this conversation about common mistakes made in estate planning. Before I go forward, I want to introduce our guest. I want to introduce first my partner, my deputy surrogate here in Essex County, Devere McDougal. He's my co-host.
Hello, everyone. Just picking up papers I dropped on the floor, so don't mind me.
Got it. I want to also introduce a young lady who is, thank you very much, Darren. I want to also introduce a young lady who is the surrogate out of Passaic County who's been doing this work for such a long time. She's been recognized throughout the state for the work that she provides, not only her constituents, but throughout the state, being a leading voice in the surrogate's office. And also, I would consider her a mentor because, when I ask questions, she's able to answer those questions and provide me advice and direction. Our surrogate, Honorable Bernice Toledo.
It is my pleasure. Always thank you for having me, and I love partnering with my Essex County brethren. Thank you so much. It's always a pleasure. Bernice Toledo.
Thank you, Judge. And I also want to introduce a young lady who is recognized as a leader, a leading voice in this space, who has provided our office directions, advice, as well as helped constituents, regarding their need for estate planning services. Her name is Crystal Edwards. Introduce yourself, please.
Hi, everybody. Thanks for joining us today. Crystal Edwards, Porthio, Bromberg, and Newman. Happy to answer any questions you may have. Dump them in the chat, and we'll get started.
Great. So, Devero, let's start off. Let's start with the most basic question. What is it that we do, and what are some of the common mistakes that you've witnessed in this office?
So basically what we do is probate wills, and when there is no wills, we pass away without a will intestate, we are responsible for appointing administrators based on the state statute. I will turn it over to Surrogate Toledo to explain exactly what the surrogate position is and the surrogate's court, because she does such an excellent job of doing that.
Thank you. Thank you so much, Deputy. So in Passaic County, as in all the 21 counties, you have one surrogate. There's only one per county, 21 of us in the state of New Jersey, plus our deputies. And surrogate means one who stands in the place of another. So what we do is we authorize somebody to stand in the shoes of another, of somebody who can't. So who can't? I mean, there's several classes of people who can't, but the main one and the subject of today's conversation is the decedent, the person who passes away. So they're here, they were here, their legal voice is gone because they've left this earth, but you know what's not gone? Their house isn't gone, their car isn't gone, and their bank accounts aren't gone. So we, as the surrogates, as the judges of the surrogates courts, have to empower somebody to step into the shoes to transact. So they, my mom passed away, motor vehicles. It was her car, but, really I'm the one that drives it and I need to transfer it in my name. They leave behind a car. When your decedent leaves behind a car, it doesn't matter who drove it, who was making the payments. You can't do anything with that car. You can't sell it. You can't junk it. You can't title until you come to the surrogate's court to be appointed to step into the shoes of the person who passed away.
Thank you very much. So, Crystal, what services do you provide as it relates to this conversation that we are having?
Sure. So we help families from kind of beginning to end. So pre-planning means putting your affairs in order before the time of your death to make sure that your family knows what it is that you want, what you have, who you want to receive it, and ultimately who you want to make the decisions to control disposition of those assets at the time of your death. Unfortunately, once people have passed away, we help their family members with maneuvering the estate administration process. It's a job. We call it a job often. There's work to be done. There's compensation that we had for that job by way of commissions, but ultimately there are responsibilities. And so our task is walking families through that process to make sure that you check all of the boxes. One of the biggest boxes that's really important to check is the tax box. We do not play with the IRS. We don't play with her little sister, the state of New Jersey. And so we just want to make sure ultimately that when doing an estate administration, you cover all of your bases.
So since we have some people that may not have watched this before, so let's start from the beginning. Let's talk about estate planning and important documents that you should prepare in an estate plan, and each individual one, if you can explain those for us and the importance of them for us, if you will, Crystal.
Sure. So I talk about the big three. There could be four, but ultimately talk about the big three: a power of attorney, an advanced healthcare directive, and a last will and testament. Of those three, which I'll explain each one, in my world, the most important one of those is the power of attorney. The power of attorney is where you're appointing someone else to act on your behalf, to stand in your shoes, essentially, for legal and financial affairs. It could be done one of two ways. It can be something that's effective immediately, regardless of whether or not you can act for yourself, or it can be what's called springing, which it doesn't come into play unless you're not able to make decisions for yourself. Personally, my preference is to have a general durable power of attorney, which is effective immediately. And the reason is because you never know when you're going to need it. Ultimately, if you don't have someone who's been appointed to make decisions for you, to access bank records, to sign contracts on your behalf, for example, and then something happens and you are no longer capable of making the decision yourself, the only other way for someone to act on your behalf is to file an application in court for a guardianship. Guardianship processes are not quick and they're not cheap. They involve 2 lawyers and 2 doctors oftentimes, though you can bring a guardianship application yourself. So ultimately, we try to avoid it if we can. The power of attorney oftentimes will allow us to do that. The medical directive, on the other hand, is a twofold document. First, it says what you want to happen in the event that you're unable to make a medical decision for yourself and your doctors feel that there's no medical likelihood that you would survive a condition essentially short of a religious miracle. Would you want to be kept alive on machines, tubes, and ventilators, or would you want to pull the plug? The second thing that document does is says who you want to be your mouthpiece to make your medical decisions for you if you can't make them for yourself. So in the COVID environment that we're in, a lot of people have been revisiting their advanced healthcare directives and just making sure that whatever their decisions are clear. Would they want a ventilator or not? Would they want a feeding tube or not? And then the third document is the last will and testament. So that's where you say, here's what I got, here's where I want it to go, and here's who I want to manage that whole process of getting ultimately my stuff to the right people. The reason that I say that that one of the 3 documents is the least important in my world is because worst case scenario, there's a mechanism to, distribute assets if you don't have a will. Although it is critically important to have one and to pre-plan. But if you don't, it's not the end of the world. It just means that your stuff may not go to the people who you really wanted it to go to. And the person who is managing that process may not be the person who you initially wanted it to be. So planning is very important. The honorable mention document is a trust. So sometimes for our fans of Susie Orman and the rest, you'll hear people say that a revocable living trust is needed and necessary because, oh my God, the probate process is the worst thing since sliced bread. You never want to do that. In New Jersey, the probate process is not overly complicated or expensive. The cost for the probate process here is a couple $100s in comparison to the thousands of dollars that it could be in other states. So we typically do not just do revocable living trusts to avoid probate. I would gladly work with the Essex or Passaic County Surrogates offices instead of having to go through the additional work that one has to do to fund a revocable living trust during their lifetime. With that said, there are circumstances where it is important. And that would be where you own property in multiple states. We don't want to do the probate process in multiple states. You know, if your intended executor lives in New Jersey and you own property in South Carolina, the easiest way to deal with cleaning up your estate after you're gone is having that South Carolina property, for example, already in an entity that your loved ones can access without anyone having to schlep down to South Carolina or try to track someone down on the phone to find out how to get the legal authority they need to act on your behalf.
So on a few of those points, with respect to a power of attorney, Ms. West is correct. It is an easy way to get things done. It's pretty cost effective. It's not complicated. So it's better to have one than not need it than to need one and not have it. You should keep in mind, though, that a power of attorney dies when the person dies. So a lot of times we get people coming into the surrogates court saying, well, I have mom's power of attorney, but the bank won't let me transact. Well, because the power was gone the minute that they passed away. And at that point, the powers there are gone, but the springing powers of the last will and testament come into play. So if you have a will, whoever was nominated executor or executrix, come to the surrogates court to get appointed. With respect to a healthcare directive, very important, especially in these COVID times. We all think we're going to be healthy for the rest of our lives, right? But we've seen so many times, especially now, where a perfectly healthy person in their 40s or in their 50s is now intubated and unable to make decisions. And this is significant. You know, do you want life-sustaining care at all costs, even though that may mean that you compromise the ability for you to get maximum pain relief? Or do you want maximum pain relief, but that may mean that your heart will slow down and it could mean, you know, imminent death, but you'll be most comfortable. So these are things that you have to think about: power of attorney, your healthcare proxy, your last will and testament. As far as there was something that you had said, Crystal, that just escaped me.
Was it the trust, the revocable living trust? Probate process being fairly easy, not expensive.
So the probate process is fairly easy. It'll cost you a couple of $100s, and what you need, just as a regular matter, you know, and there are variations, but to start, you need a copy of the death certificate, a list of next of kin, a list of assets and their approximate values. You don't need the exact values. And be ready to pay court fees, which will be a couple of $100s. A standard will be about $150, maybe. If you don't have a will, of course, you're not going to bring it in. That's called an administration. That'll also cost you about the same thing, unless you have a small estate. With respect to wills, so it really is. In this instance, you don't want to be penny wise and pound foolish. A lot of people go on the internet to get a will, and that's not the way to go, because it's almost better to have no will than to have a will with errors on it. Because if you have a will with errors on it, there is no way to get that appointment done until you file a complaint and an order to show cause. So everything essentially freezes, because you have a will, and you have to file a complaint to have that will admitted. So that's where the problem is. If you have no will, then it'll pass according to the laws of intestate succession. And if you have a nuclear family, and nuclear meaning you have one spouse, you only have children from that one relationship, then that's fine. But you know, how often do we see, more than half the time we see that families are not nuclear families? So in a situation like that, you should have a will. Because the laws of intestate succession may leave out, depending on who dies first, whoever children that are not from the most current marriage. But with respect to the will, you have to make sure it's done properly. It is best to go see an attorney. You have to make sure that it's properly witnessed, that there's a self-proving affidavit. And a self-proving affidavit means that when you die, if you have a will without a self-proving affidavit, that's fine. It's not the end of it all. But the problem is then that you have to chase down the witnesses on your will. And how's that problematic? If you executed your will 5-10 years ago, Where are those witnesses now? They may be out of state, maybe you've lost touch with them, and that becomes a problem. So invest the money on the front end for an attorney to get a will appropriately prepared for you and drafted.
And one thing that I do want to highlight and then pose to you if I can. So oftentimes when people hire an attorney to prepare a will, the attorney will keep the original in their office in a will vault so that it's safe and protected, right? The reason for that is because in order to probate it, the surrogate's office requires an original. For clients who take their original will with them, or for families where they go online and they find a little something and they put it together and they sign it themselves, can you talk about the impact of staple holes and if a will has been taken apart, and what happens if someone has written on the will? Like,
So,
let's say they cross out a whole paragraph. They just,
and we see that, and sometimes they don't even cross out that much, but it depends on what the effect is, right? So in Passaic County, and I think in the state of New Jersey, the surrogates court is meant to be user friendly, right? If you go to other states, it's very litigious. No matter what, even if nobody's contesting, you have to go through the official complaint and court process. Not in New Jersey. Generally speaking, we want will with no crossouts. You have to be very careful. However, staple holes, listen, I don't get hung up on staple holes provided things line up and the page numbers are consistent. So if there's page numbers, page 1 to 9, and there's no page numbers missing and the paragraphs are in order, I'm okay with the staple holes. I've seen and heard of horror stories, not in New Jersey, but in other areas where they say, well, you pulled out the staple, now you have staple holes, it's not in perfect condition. I am of the mindset, as are most of the surrogates in the state of New Jersey, that you want to be outcome determinative. So if on its face it looks like it's the appropriate document, it's a clean staple hole, we keep them in. If there's a cross out, sometimes there's a squiggle or the pen slid, that's kind of okay too. Here's where it's a problem, wherever that squiggle is or where you've made a cross out actually changes the outcome of the will. So if you say, well, I nominate Billy Jr. to be my executor, but somewhere along the line you change your mind and you don't want Billy Jr. to be your executor, you want Mary to be your executor, and you just cross it out and put in Mary, you have a problem, because that's really changing the heart of the will. The person who's going to be in charge to execute your wishes is at the very center of who you, as the decedent, speaking to us from the grave, who you trust to act. And we don't know if that cross out happened after all the signatures came into play or not, but it can be problematic. Small things we can let go with something like an affidavit. Sometimes there's a problem with, the date is on the body of the will, but not at the signature line or something like that. Or maybe the witness is dated, but the testator didn't. Well, with a witness affidavit, we can reconcile that to make sure that we can get this done for you quickly and easily without having to go to court. Like I said, we really try to be user friendly. We try and do what's best for the family, and we try to carry out the intent of the testator. And generally, if a testator has gone through the trouble of executing a will and putting out wishes, then they didn't want their family to go to court and duke it out and go through this whole long and arduous process. They actually tried to plan and prepare. So we do try to carry that out. There are instances, though, changing executors, changing percentages of who gets what, where we cannot overlook it. And what happens is I execute a judgment of doubt. It's called a judgment of doubt or difficulty. At that point, I lose all jurisdiction. Nothing happens until somebody files a complaint and an order to show cause.
So I just want to, as Judge Toledo said, there is discretion in the surrogates court. Most surrogates, as she said, I'll try to be as user friendly as possible with the constituents, but there's some things we just can't do. If there are things are what we would consider in the legal realm as harmless error, as she said, a date. Let's say you put August 2017, you didn't put August 13. That's harmless. We're not going to do much with that. But now, if staples are taken out, and as she said, If there's other things that are wrong with it, then we start to question whether or not somebody, altered this will. We don't know because the seed is not there. Those things become problematic. And so, as she said, don't cross out anything. If you want to change your will, you want to do a codicil, which is just an amendment to the will. In this day and age with computers, as Crystal would tell you, that's easy to do. Don't try to save a buck and try to cross it out because you cause more problems down the road. So we do have some discretion, but the court rules don't allow us to do anything when you start making. Technically, if you cross out anything, we're not supposed to do anything, but we use some discretion if it's minor. But as she said, if you start changing names or you start changing who gets what, we're not allowed to do anything but pass it on. We can't act at that point. So be very mindful of that. In this case, when you think less is more, that's not necessarily the case. You say, oh, it's just, no, it's not necessarily the case. There is a process that we have to go through. So we'll use our discretion when we can, but at the end of the day, we have to follow the statutes and the court rules. So be very mindful about changing anything in the will. Do a codicil if you want to change it. And I'm glad you brought up the topic because I think we should talk about errors and mistakes or misconceptions people have in these documents or even in a planning phase. So let me just ask a question in terms of the planning phase for Crystal, because a lot of times I know people come to you and for whatever reason, I guess just like a doctor, they don't want to tell you everything. But in order for you to do what you need to do for them, they need to communicate with you in terms of family dynamics and things of that nature. Can you speak towards that? Not talking about family dynamics or talk about assets they may have or may not have.
Yes. So I'll say the biggest thing is just a cautionary tale of when you're seeing an attorney to prepare a will. Unfortunately, this practice area, like preparing wills, estate planning, estate administration, probably real estate is another practice area where everyone with a law degree believes that they can prepare a will because it really can't be that big of a deal. It's just a will, right? But there are so many nuances to this area that people are not aware of until it's too late. So if you're going to see an attorney for the preparation of a will, the first thing that should happen is they should ask you to complete a very comprehensive questionnaire about what type of assets they have, what type of money they have, and what their family dynamic is. And forces some of the discussions to happen pretty organically, because you can't really prepare a will for someone if you don't know that they own property in New Jersey, in Nigeria, and in California. I mean, this is just information that you need to know. So the first thing is transparency is critically important. Depending on the family and the family dynamic, the people who are around you are also critically important. So for example, oftentimes a family will call and say, hey, a son will call and say, hey, my mom needs to redo her will. Okay, fine. Mom will come in and she'll have son with her and she'll tell me all of these wonderful things that she wants to do. But ultimately, my goal throughout that process is to make sure that what mom is saying to me is without the influence of someone else and is truly her desire. So sometimes a cautionary tale is just to take a step back. If you're someone whose family is pressing you, right, day by day by day to do planning, that's not necessarily a bad thing. That's a good thing in wanting to have less work for them. But it's also something where you have to approach it from the perspective of what's best for you. Spouses is probably the biggest issue that I've seen in my career with people telling me the truth about. And that sounds crazy, but it happens. So someone will come in and say, hey, I live in New Jersey. I got a couple kids. And, what's your marital status? Single. Yeah, lies. They're actually estranged and they've been estranged for 30 years or they've been estranged for 25 years. Those types of details are really, 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 really important. An attorney is not going to breach confidentiality. short of you walking into the office and saying that you're going to commit some horrific crime that is getting ready to occur in short order, I mean, it would have to be major. An attorney is not going to breach confidentiality with respect to your estate plan. So you can be honest that you've got assets somewhere else, or that you've got cash that you took out of circulation that you probably shouldn't have that's in a safe deposit box. I mean, these are things that people need to know. The one thing that I will say about the confidentiality and feeling comfortable talking to your attorney is about spouses that are married and come in the office together and are doing their estate planning together. There is an inherent conflict of interest when you represent two people who have interests that are not the same, right? So in an estate plan, your spouse may want to benefit his mother, and you may not want a dime to go to your in-law. That on its face looks like a conflict of interest, but it could be resolved. So ultimately, here's the thing to know. If you're married and you hire an attorney, generally, there are no confidences among the relationship. So when your spouse goes to the bathroom, not a good time to share that you've got a side family. Not a good time. That's going to come out, okay? But short of those issues, transparency is critically important, and it can save you a lot of money. The estate administration process is based on assets that were titled to you or that were payable to your estate at your death. If you fail to share that all of your money is tied up in a joint account with your cousin, our work with respect to a will or your own personal endeavors with preparing your will may be for nothing, because the presumption is that joint accounts pass to the surviving joint account holder. So even the smallest of details is critically important in making sure that ultimately what you put on paper is going to be able to be implemented when you're gone.
So when you talk about the smallest
side family issue, FYI.
Well, Charles Carruthers had a side family, and they didn't find that out until much later.
That's right.
So it definitely does happen. So I want to ask about, you talk about the simplest things, and I know Surrogate Toledo probably sees this a lot. Simplest thing could even be making sure your name is spelled properly on the will, or if you have multiple, also known as, that they're on there, because at the end of the day, it's a legal document. And if you spell your name differently, how do we know it's truly you? Because multiple people have the same name. So you have to be mindful that you don't want that to hold up the process. Even mistakes like when you talk about spouses, if you don't, a lot of times you put a spouse on the will and you separated you just separate, not legally divorced, then technically that spouse still is in charge of your estate and still in charge of, or still will inherit. If you are divorced, some of the things that we rarely see, the better attorneys do a good job and say, my ex-spouse, who is my friend, to let it be known that, because there is a statute here that says that if you are divorced by operation of law, you no longer are the executor, you no longer will inherit. If that's not what you want, because you're divorced, because I actually saw a will here today where the gentleman made sure everybody knew that was his ex-wife, yeah, which was excellent. So simple mistakes like that, where you think, it doesn't matter, can cause a lot of problems. Is that correct?
Absolutely. And in the post 9/11 world, where your legal name is so important, it extends beyond just you. It also goes to the people that you're appointing. So if you're appointing your friend Doug Smith, but Doug's legal name is Anthony Douglas Smith, we need to know that his name really isn't Doug Smith, because when it comes time to qualify to be appointed as the executor of the estate, the surrogate needs to feel confident in knowing that the Doug Smith listed in the document is the same person as Anthony Douglas Smith that showed up in the office.
Right. I just want to point out to everybody that for some reason we lost Surrogate Toledo and Surrogate Kenny.
but we're good. We can do this.
But we're going to continue to move on. I'm sure that Surrogate Kenya is working on getting both of them back on screen. So let me just move on to I use the technical terms. If you could talk about both of them, because I know this happens a lot, especially when we talk about people that have wills. Let's talk about ademption and abatement. People get a little confused about what happens when an asset that specifically requested that to go to one person, but when they die, it's not there. What happens then, or abatement in the sense that there are not enough assets to distribute according to what the will says. What happens? So if you can explain those two terms more of in layman's term and explain what happens in those situations.
Yep. So I'll do it in reverse order. So abatement. Okay. The issue there, and this goes back to one of the things that Surrogate Toledo said earlier about don't cut off your nose to spite your face, and it's really important to see an attorney about preparing a will. There's an order of priority that things in the will that are listed in the will actually get paid out. So if someone says, I give $5,000 to my friend Susan, and I give everything else I own to my daughter Sarah, what they are doing is saying that the first $5,000, regardless of how much money I have, goes to my friend Susan, and the balance of it will go to Sarah. So if the only thing that exists is $5,000, you've essentially disinherited your child. So that's called a specific bequest. After specific bequests come what we call the residue or the residuary, the everything else. So with abatement, that's where you don't have enough assets to pay the debts of the estate, the taxes of the estate, the expenses of the estate, the specific bequest, in my example, that $5,000 to your friend, and then have anything left at the end to go to anyone else. So if you're in a situation where the estate is insolvent, which means that the expenses of the estate are more than the amount of money that's in it, you're not really in abatement land. You're just in, we need to satisfy these creditors and there's nothing left for anyone else. Abatement would come in the event that there is something left, but there may not be enough to satisfy all of the beneficiaries within the estate. So the one thing that I'll say with that is when you're planning for your own, when you're doing your own estate planning, it's a revolving process. It continues. It's not a one-time thing. As your life and circumstances change, you want to revisit things. In my example of giving $5,000 to a friend, maybe that's what you wanted to do when you had a house and $500,000. If due to life, you only have $20,000 left, maybe you don't want your friend to inherit a fourth of your estate. So that's abatement. Redemption, on the other hand, is where you say, I want my house to go to my son. But by the time you pass away, the house is no longer owned by you. What happens then? And so a properly drafted will would acknowledge what you want to occur. So for example, you may say, I want my house, or if I no longer own my home, the value of the net sale proceeds of that home to benefit XYZ person. If you don't do that, on the other hand, if the asset is no longer there is nothing to distribute for that specific bequest. One of the questions that came in from someone on point here is, as the tax laws change, should it be mandatory to redo your will completely as opposed to an amendment? I'm not going to say that it should be mandatory. It's going to depend greatly on what your existing will says and what the tax law is at that time. I am not personally a fan of codicils. Codicils are amendments to wills. Codicils, you can have 1, 2, 3. It's much more difficult to track. If I prepared your will, but you did a codicil and your family comes to me to get the will, I have no idea you did a codicil and essentially made changes to the will. So my personal preference is always to do a new will whenever you want to make a change. At the same time, though, I do acknowledge that there's a financial component to that potentially. And so we make, arrangements as needed to do a codicil. If the tax change greatly impacts how you would distribute your estate, like if you're changing more than who the executor is going to be, if you're changing more than who the executor is going to be, generally, I think that you need to do a whole new will. The tax laws change often, but not often enough where you would be making changes to your will every year.
So let's go back to your example about the house. So if the house is no longer in the estate, or let's say the decedent, before they passed away, they're in process of selling the house. There was a contract. To sell the house. And I can't remember what the individual you said, but let's say Sally. Sally said that her son was going to get the house, but she decided to sell the house, died before it was sold. Is he entitled to the proceeds? If the will doesn't say that he's entitled to it, is he entitled to the proceeds?
No.
The will has to specifically indicate that he's entitled to, or they can substitute the value
for that value. Correct.
So just want to make sure that was clear with everybody.
And houses, so, Deputy Surrogate, we've been dealing with houses a lot. So I think that not all, but the vast majority of my estate litigation issues in Essex County have all been with real property. Mom or dad passes away and they have a multifamily house and there are tenants in the home, and maybe a family member lives in the house or not. And ultimately what's going to happen when mom or dad dies and you've got kids who have differing opinions about houses. So the biggest asset for me to make sure is very clear with what the client wants is real property, any home. If there's a child who lives in the home and there are other children, we need to be crystal clear, no pun intended, on ultimately what you want to happen. Do you want that child to continue being able to live in the home rent-free without the impact of the other siblings or not? Do you want that child to be provided a first right of refusal to buy out their siblings' interest because it's been their home forever? There are so many things that we have to think about that are more than surface level. For people who have multiple children, I'm one of them, and I've got little kids, but 20 years from now, 40 years from now, 60 years from now, I want to avoid the two of them fighting based solely on the fact that my daughter got more ice cream than my son.
Right.
They were 2, 3, and 4. Right. And that's what happens. Like children are adult children oftentimes play nicely with each other as not to make mom and dad upset. But when mom and dad are gone and that neutral party that keeps the family together are no longer there, that's when these issues creep up. And so we really try to spell out what your desires are as much as humanly possible. For the person who had the comment about, are there law firms that will help you with estate planning pro bono? I would say that it's possible, but estate planning is still something that is seen as more optional than mandatory, unfortunately. So it's not an area where I think you're going to get a ton of firms that are excited about providing that on a pro bono basis. What I will say, however, is that if you prepare your own will, you certainly can, pay a couple $100 for a consultation, and an attorney can go through with you whether or not the will that you have prepared accomplishes your goals. And so that would be an economical way to kind of kill two birds with one stone, save cost, but also make sure that what you have is effective.
Right. Okay. So there's a question from Nicole Michelle. This one is, co-signers on a mortgage have what interest if a person dies without a will? I'm going to use the word it depends, but I'm going to let you go ahead and answer it. So it depends.
So co-signers on a mortgage do not always have a joint interest in the property. So my first question in answering that question would be, is there an ownership interest in the property, or not? And is the co-signer ultimately a beneficiary of the estate? It depends. But after we're done with this, feel free to send me an email and I can kind of walk you through that process on a personal level. I'm not sure if that's going to be general enough for the masses, but I'm happy to talk to you after if you have questions.
And I'll just add this in terms of on the surrogates court side, which we've seen a lot of times, and I've done real estate prior to this, and so I know a lot of times people take names off of deeds, put names on deeds, even though let's be clear, what a mortgage is collateral that you're giving on the house. It's not the underlying loan. The money that you get from the lender is the loan. When you use the house as collateral to get that loan, that is the mortgage. You are giving a mortgage to the lender. So let's be clear on the terms, because a lot of times on TV, you hear them say, we're going to give you a mortgage. They're not giving you a mortgage. They're giving you a loan, and you're giving them collateral. You're giving them a mortgage. So a lot of times we see here in the surrogates court that transaction has happened without the lender knowing. And those contracts do have something called an acceleration clause. You start playing around with changing names on the deeds without them knowing and giving permission, they can actually have that note come due and make you pay all the money. So be mindful of that, be careful of that. So one of the things that we see is a lot of times, and I'm going to make an assumption that is what's happening. So what ends up happening is the family member dies and the other person whose name might be on the note is trying to now work a deal with the lender. Well, but you don't own the underlying property, because let's say the underlying property was in the name of a husband and wife. Well, it went to the other spouse. Now they want us to issue a short certificate for the spouse that died. Well, we can't, because there's no asset. The asset automatically by law went to the other spouse. Therefore, for you to communicate with the lender, we can't give you anything. So unfortunately, you're going to have to order show cause and verify a complaint and ask a probate part judge to give you an order to allow you to communicate with the lender. So be mindful of when you start playing around with deeds and they look like it's the most prudent thing to do. And I'm being blunt. Actually, a lot of times, a lot of people are committing fraud. So be mindful of that. Don't just start changing names on deeds or anything like that. You know, especially if you pass away or family member pass away, it can cause even more problems. So be mindful of that.
And one of the things I'll say on that note about just changing deeds. So in addition to my estate planning hat, I'm also an elder and special needs lawyer. So I can't help but talk about what the impact is of changing a deed during your lifetime. You know, just adding someone's name to a property could certainly disqualify someone for long-term care benefits that are available through the state and federal government that a lot of us are going to need towards the end of our lives in order to pay for the cost of long-term care. So doing a deed is not something that should be a do-it-yourself. Like, I'm generally okay with someone preparing their own will, provided that they are willing to have an attorney review it to make sure that it's okay. But I draw a line in the sand with respect to real property. Everyone thinks, oh, I'm gonna just go get a quick claim deed and I'm gonna, do X, Y, and Z. It is much more complicated than that. And there are other implications, especially if there's a mortgage on the property. A mortgage on the property, transferring a house could call up a mortgage, and no one has just a little easy $325,000 sitting that they can just pay over tomorrow when, the lender says, give me my money. So just be careful and be cautious.
Right. And here's an excellent question from Donna Judd. That's on the topic we talked about with the house. So it says, so if both parents passed away with no will and have a house that's paid off, there are 3 siblings. And I like this part because people always think the oldest sibling is in charge
Right.
because of the birth order. So the oldest sibling lives in the house and we would like to keep it that way. What do we need to do to put the house in all 3 of of the siblings' name?
Okay. So first step would be whichever parent was the last to pass away, you have to make sure that one of you has letters testamentary or letters of administration that is the legal authority you need that you get from the surrogate's office in order to execute a deed or any other business on behalf of your parents. So that's part one. Once you check that box, the next box we have to check is to make sure that there were no taxes that were due for that property. I'm not talking about property taxes. I'm talking about New Jersey estate tax. We don't have New Jersey estate tax today, but we had it up until 2017. So depending on when the parents passed away, we may need to check that box too to make sure that there's no estate tax implications. If anything from the parents passed to someone other than a child, regardless of this house, then you're also in inheritance tax land, and we'd have to check that box also. Assuming that those two are fine, you would have two options of how you can set up this arrangement so that 3 siblings own the house, but 1 sibling can live there. You can do it the what I'll call informal way, which is the deed is changed to be from the parents' names to the 3 children. And then you just do a simple lease agreement between each other, saying that one of the siblings is going to rent, right? And maybe the rent is just covering the carrying costs for the property, whatever it may be. In that circumstance, you have to remember that capital improvements would be a requirement of the landlord, so all 3 siblings. So if one child lives in the house and there's a roof leak, all 3 of you would be subject to paying the improvement, not just the child that lives there, right? So the informal way is still kind of formal, doing a lease. The greatest benefit, but it does have a monetary commitment to it, is providing that child with a life estate interest. So a life estate interest is where you're saying, hey, sibling that lives in the house, we as your siblings recognize that this is your home and we want to give you a lifetime right to live in this house for the balance of your life. And that's a deeded interest in the property. The downside to a life estate interest in the example that you raised is that a life estate has monetary value. So if the property is sold, the child that's the life tenant would get a percentage of the sale proceeds based on their lifetime right to live there. And then the difference would be divided a third, a third, a third. So if ultimately the desire was just to benefit the 3 of you, but to let one live there, I would say get the letters that you need to have legal authority to transfer the property, retitle the house into the name of all 3, and then have a lease agreement among you so that everyone is clear on who's going to pay the property taxes, who's going to cover a repair, who's supposed to maintain the grounds, the snow removal and the grass. I mean, down to the most minor detail you want to spell out in that agreement so that everyone is on the same page.
And I think mentioning life estate was important to mention because most people don't understand life estate, and there is a monetary value. There, IRS has, schedules or, charts to calculate it. And when you sell it, and then when you sell that house and there is a life estate, that person is entitled to proceeds and they get a 1099 and it becomes taxable to them. So you have to be mindful that, I'll put it this way, almost anything that you do transactional wise is taxable unless you know otherwise. So I'll tell you what my tax professor said. So as far as you're concerned, unless you know otherwise, everything is taxable.
That's right.
So definitely with a life estate, you got to be mindful of that as well. If you want to go that, there's a tax implication with that, but with mostly everything as Crystal was saying, talking about estate tax, inheritance tax. So you always got to be mindful that if you're not familiar with it, you should talk to an attorney that's familiar with it or an accountant that's familiar with it. And I just want to make this note, and Crystal mentioned it earlier, but I'm going to pretty much just reiterate what she said in terms of attorneys, but also with accountants / CPAs, is that although attorneys by the court rules say that we can pretty much do, once we become attorneys, we can do anything. The only caveat is that we need to get the prerequisite knowledge. And however that's done, whether it's communicating with another colleague or taking courses, we need to get the knowledge. But technically, we can do any kind of work. I often use the example, though, you wouldn't want me, for instance, you won't want me to be a defense attorney on a murder trial because I think you're gonna get locked up. Yeah. So be mindful of who you utilize, whether it's an accountant or a CPA or an attorney. I'm not saying that those individuals can't get up to where they need to be, but the more complicated your situation is, the more experience you want that individual to have. So myself and Crystal aren't knocking anybody's skill level or anything like that, but the more complicated your situation is, you want somebody with that skill. And if it really is complicated, it probably will be involved in a lot of money, the loss of money if you don't get the right person or make the right plans. So don't skimp. Skimping again. I think Judge Salita was saying that earlier. Don't skimp in the beginning, because in the long run it can hurt you, and we've seen it here in the surrogates court with people not doing proper estate planning, or saying, as Judge Salito indicated earlier, saying, "Oh, I was the power of attorney, therefore I can still do." No, power of attorney extinguishes when the person passes away. So a lot of times just pay the money to get professional help. I like what Crystal said about just simply, if you do it on your own, just have a lawyer review it. It costs you less money, but at least it actually does what you want it to do. And then they may explain some things that you didn't think of and that you may want to do. And of course, they're going to charge you for the extra, but it'll probably still be worth it. So don't let cost itself scare you for doing a proper plan and making sure your loved ones are taken care of, or even yourself when it comes to having an advanced directive. You want to get that reviewed every so often. You might change your mind about whether you want to be on a respirator or not. So when life changes, you look to your documents and change your documents accordingly, whether it is to do a codicil or not to do a codicil, as Crystal said, because, which is true this day with computers, if you're using the same attorney, it's not going to cost them as much to make a few changes here and there and just reissue a new will. And so you understand the new will that's issued supersedes the old ones. You probably would want to shred that old one. So just in case family members find the old one, they're not probating the old one as opposed to the new one. So communicate as well. Communicate with family. That's probably one of the other big mistakes, besides not communicating with your attorney, everything you need to communicate, not communicating with your family members, not letting them know some of the things that you're going to do, you plan on doing, because some of the issues could be sticky. You got 3 kids, everybody's not getting things equally. You might want to have that conversation in the beginning to explain why. Because just this question talking about, even though it's saying older sibling living in the house, but people do believe because you are the oldest, you're entitled to more, you're entitled to do that. So you should have that conversation with family members as well, just to make sure that there is no will contest down the road. Because family dynamics, your kids, your family members, who's willing to litigate, who's not, who wants to cause a stink. Have those conversations in the beginning, and that will probably avoid some of that, litigation, or as Crystal said, some of those things that they harbored for years comes up later. It can avoid those things down the road.
Yeah, and for Miss Judd, one of the mistakes that I would say is easy to make is to assume that everyone is going to do the right thing. Right. It's an assumption. And the only reason we say that is because lawyers are in the worst case scenario business. So you don't come into my office or to an attorney's office for us to tell you that everything is roses all the time. I'm going to tell you what happens if the relationship breaks down, and we've got to defend you so that ultimately you're in the best position. So the biggest mistake that could be made, that I would hope that in that example and others would avoid, is to really reduce your agreement to writing, memorialize it on paper, so that it's not just about the siblings, it's also about their kids, their spouses, right? Making sure that anyone who is involved in the day-to-day life of each of the siblings understands ultimately what the relationship is and what the limitations are.
You just made me think of an example. Recently, I came across somebody who had only one child, and they tried to get the individual to do a will, and they said, I don't need to do a will. You're my only child. You're going to get everything. Fast forward, come to find out she had a boyfriend, fiance, and the son went on and became an administrator because he was next to kin.
Mm-hmm.
Turn around some months later, this boyfriend produces a will.
Ooh.
And so now, obviously, they got to go to court because everything was left to the boyfriend. And one of the assets was a house, which was, at this point, the house is worth probably about $500,000.
Yeah, we're gonna fight about this.
Right. So they got to fight about it. So, she could have avoided all that, even though what she was saying technically is true. That's the only child, no spouse. It would go to that child. But not understanding dynamics of relationships, here's somebody popped up, and because they might have lived in it with her for years, said, I think I should be entitled, generated a will. It may not necessarily be, my personal opinion is not a valid will, but they have to fight over it because she didn't do a will. So those are common mistakes people make too, not doing a will because they think that everything is going to go to them, but things could happen. I see another question.
So I think we can answer this last question, and then we've got to exit stage left.
Exit, yep.
But this question kind of goes into what you were saying. So when you have a will, it's not over at that point.
Well, let's read the question first. So it says, how does the court view changes in the will and pension beneficiary when a person have documented mental health issues? Are the person's wishes followed in the case? Okay, so that's a little more about. Okay.
Yeah, so just because you have a will doesn't necessarily mean that it's over at that point. People can object or can contest a will. The reason to contest the will may be that someone was subject to undue influence. So in the deputy surrogate's example, someone may be whispering with a little pillow talk saying, your son ain't worth nothing. He ain't here. I'm the one taking care of you, and is kind of creeping in to your mind to get your money. That's one example. Another example may be that the person mentally does not have capacity to make decisions for themselves. And so while they may have in fact signed a will, mentally they didn't understand what it was that they were doing. The court does not raise those questions on your behalf. So the only way that would be brought to someone's attention is if a family member filed either, I'll say contested the will,
right,
on the basis that there was either in the deputy surrogate's example, undue influence, or in Miss Nicole's example, that the person did not have the capacity to execute it. Same thing with beneficiary designations. A third party, pension company is not going to get involved with someone arguing that the designation was done without the mental capacity to do so. You'd have to get a court order to change that. And so that would be done by filing a verified complaint and an order to show cause with the New Jersey Superior Court.
Because bottom line, the burden of proof is on you to prove that they didn't have the capacity or there was undue influence. And so you have to be proactive in those things. And I just want to mention this one thing about mental capacity in the will. You can, wills are strange. If you have a momentary capacity to understand what your assets are and who should get them, it's a valid will. You can, that person can, the day before, not know your name or whatever, but the next day know it. During that moment of lucidity, that will still can be valid. The burden will be on you to prove that they weren't lucid at the time, didn't have the legal capacity. So, especially if somebody has some type of dementia, you want to keep track of that when they were first diagnosed, who their doctor is, because you're going to need all that as your proof as to whether or not their capacity was there. And I will say this: once somebody has been declared incapacitated, let's say, they did a guardianship with the surrogate's court, they were declared incapacitated. At that point, they can't do a will, and you can't do a will for them neither. Unfortunately, at that point, you have to rely on the testate statute and then rely on the court system, because they are awarded the court to, if they did have a house, you can't just sell that house. You have to get permission from the court so forth and so on. So a will cannot be drafted for somebody who's been declared incapacitated by the courts. So I just wanted to make mention of that as well. And it is now, what is it, 1:04, and we never really got the surrogate back. Need a surrogate back.
He's been working in the background. So we've been all right. So
if voice is there, no picture.
Right.
So,
yeah, voice
so he just disappeared. Yeah. So I want to thank Surrogate Toledo, who looked like she was on a road trip, for taking time out during her road trip. When you're on the road, as we all know, you lose connection. So that appears what happened to her. So I want to thank her, and I apologize on her behalf as well for losing connection. I apologize for Surrogate Kenny. It happens. Technology it is what it is. So I want to thank him for making sure that this happened. I want to thank Ms. Crystal West Edwards, who comes on quite often to help us out and give us wonderful information for coming on. And if you have any last things you want to say, I'll let you say them before we sign off.
If you have any questions, you can contact me at 973-889-4263, and I'll put it in the comments for everybody. And otherwise, have a great day. We'll see you next time.
All right. Take care, Takesha. Take care, everybody. And I'm glad you guys found it informative. Have a great day.
Bye.
Bye.